Morning, Your Honor.
Mr. Barrick, you are the appellant, representing the appellant.
Yes, Your Honor.
All right, your 20 minutes begins when you say so.
I'd like to reserve 5 minutes, Your Honor.
You got it.
May it please the court, Ryan Barrick, Paul Barrick Nadu, Clearwater, Florida, on behalf of Brittany James. This is a case where an employee of a public housing authority was fired because she reported child abuse and neglect occurring in one of the units of the housing authority against an infant resident of the housing authority.
Who did she report to?
She reported it to her supervisors and to the police.
How did she report it to the police?
She called the police.
She called the police.
Yes. There is evidence in the record as to that fact. I don't think there's really any dispute. The phone records of her calling the police are in the record. And she also reported to supervisors at the housing authority. This court's review of the trial court's decision is de novo. The trial court erred in granting the employer's motion for summary judgment because the trial court used an overly restrictive reading of section 39.203 of Florida statutes and did not follow the summary judgment rules. The trial court erroneously found that the housing authority was not a facility serving children and that it even had to be a facility serving children in the first instance. The trial court also erred in...
Let's break that down. So
okay.
I think your argument, you have two basic components. If you challenge whether the housing authority is a facility serving children, which under your interpretation could include places like Chuck E. Cheese. But if we agree with you, your next argument, if we disagree with you on that inquiry, your next argument is that regardless of whether the housing authority is a facility serving children, she independently has a cause of action under 2B. Do I have that right?
I think you can look at it from either perspective, but yes, there are two different bases. 2B says any person making a report under this section doesn't have any qualifiers at all. It says any person making a report under this section. And to be clear, this section is the entirety of 203 because the Florida legislature has instructed us in the preamble and throughout. There's a series of cases.
You and your friend on the other side make mirror image arguments on this, on applying the whole text canon to this section. And your position is under 2B that regardless of whether the 2A is in play because it is or isn't a facility serving children, any person who makes a report for child abuse enjoys the cause of action that's afforded by 2B. Your opponent says, and he can correct me if I misstate this or don't recite his complete argument. He says, we've got to read these together. One is the sword, one is the shield. And I think A is the shield and B is the sword, but they have to be read together because B is the enforcement mechanism for A. What do you say to that?
Well, I say that that there's a number of points. First, they are in fact independent, and the legislature has specifically said this section. It didn't say this subsection. So the legislature has instructed the court that they are to look at the whole section, all of chapter 203, not limit it to the second half of 203. I would also say that they are different. They are inherently different provisions. 1A deals with reprisal or discharge. Now it's not there's certainly an argument that A is talking about reprisal or discharge. It could mean a number of different things that are different than B. Also, I want to emphasize that we look at the legislative intent. And the legislative intent, if we go to look at a legislative intent, which I don't think we necessarily need to, because I think the plain language of B is clear where it says this section. But if we look at the legislative intent, the Florida legislature has specifically advised us that the prevention of child abuse is a priority, and that's in.
So you're referring back to the general statement of purpose at the beginning of chapter 39, which is a comprehensive scheme, sets up a comprehensive scheme to protect abused and neglected children through a variety of means. So you agree with that, right?
I do, and it also says that it is to be liberally interpreted. I mean, to the degree that we look at the legislative intent is clearly to have a cause of action for people who report child abuse. That's what the idea is.
Well, chapter 39 is not exclusively concerned. This is one section of a pretty comprehensive statutory framework involving, sheltering children, terminating parental rights, et cetera, et cetera. And I don't see anything in this specific section that enhances the general legislative purpose that's announced in 001, which is, of course, remedial and, to be interpreted, I think, most favorably to children in the circumstances that the statute is designed to protect against. But I'm not sure that the legislature was quite as concerned with employment relationships in the context of people reporting the abuse as you would have us infer from that generalized statement in 001.
I mean, I would respectfully disagree because the legislature specifically said any person making a report is protected. There's really not broader language than they could use other than the any person making a report. That there is a societal interest that is being advanced here in protecting people who make reports. I mean, the legislature specifically, if you look at it, they even put in a rebuttable presumption, right? I mean, that is not a legislature that is oblivious to this issue or that isn't concerned with this issue. This is a legislature that is saying we are concerned about people losing their jobs for reporting child abuse, and so we're going to protect any person who makes a report under this section.
And then going back to what your opponent has said, and there's some appeal to this because we do try to read statutes in a way that are harmonious, and that there's no surplusage, and that all the provisions have meaning and that they fit together in a way that makes sense. And so your opponent says, 2A says thou shalt not, and 2B says, if you do, then if the report is made and you suffer consequences, you have a private cause of action. And so let's just ask you, if a person making a report under this section shall have a civil cause of action, and that could apply to anybody making a report of child abuse at Chuck E. Cheese's.
If they're an employee of Chuck E. Cheese and they see one of their coworkers sexually abusing a child in the bathroom, and they go to the manager at Chuck E. Cheese and say, hey, this coworker's sexually assaulting a child in the bathroom, and then they call the police and say, hey, this coworker is sexually assaulting a child in the bathroom, and then they fire the employee who reported that at Chuck E. Cheese, I think that person has a cause of action under the statute. Yes, Judge.
Why wouldn't that cause of action be under the whistleblower statute?
They can have more than one cause of action. This is a specific cause of action that deals specifically with reporting child abuse. It doesn't have, there are requirements under the whistleblower cause of action. The public, well, they might, let's roll back and say there's a difference between the public whistleblower statute and the private whistleblower statute. So in the case that you're describing, that person might have a claim under the private whistleblower statute, but they wouldn't have a claim under the public whistleblower statute because Chuck E. Cheese isn't a public employer for purposes of whistleblower statute. So I think
you're ultimately, I'm concerned that what you're advocating does require us to ignore the language of 2A having to do with facilities serving children. And I appreciate that it's not defined, and we can talk all day long about how broad the legislature meant for us to apply that term. But given the context of its placement in this chapter 39, facilities serving children does strike me as being something a little more limited than every potential opportunity that children could be served, like at Chuck E. Cheese's, and more of either a government or private agency whose primary purpose is to ensure the welfare of children.
But again, it doesn't say, let's be clear, it doesn't say facilities whose primary purpose is to preserve the children. It doesn't say anything. It just says facilities serving children. That's not language that's used elsewhere in the statute. It's not language that's used elsewhere, anywhere in the Florida statutes. So we're looking at a remedial statute. We're looking at a situation where we have a specific instruction from the Florida legislature that we are to apply this broadly. And so if we're to apply it broadly, and that's what they say as to the entirety of Chapter 39, and we don't have a definition of facility serving children anywhere, there's no basis to insert primarily serving children, right? I mean, that's really what the trial court did, is he said, well, primarily serving children. And let's be clear, the St. Petersburg Housing Authority, approximately 50% of their residents are children. Right? They are serving children. They're not a business. They're not an entity that ignores family. They are.
Under your theory, the legislative intent was to essentially expand infinitely any given business's liability in Florida, if it so happens, for these types of employment claims, if it so happens that that business served children, whether it's a Happy Meal, Chuck E. Cheese's, or the Bright Horizons Charter School, whose purpose is to deal with displaced and abused children.
Well,
it doesn't matter.
So let's be clear. Based on the facts of this case, they absolutely served children, right? There's no dispute that they served. There's no basis to dispute that they served children.
Somewhat derivatively, right? I mean, the way the children are there is that their parents sign up to receive these housing benefits that are afforded through the program behind the building, behind the authority. But the children are sort of incidental, and you certainly don't need a child to qualify for the housing benefits. And the program, they're not providing specialized programs. Sometimes they watch kids in the office, and certainly they're required to ensure, to provide a habitable environment. But the children aren't the ones that are showing up asking to be served in a traditional fashion like they would at a school or a pediatric clinic.
Respectfully, Your Honor, they absolutely are. My child does not have if I send my child to a private school, my child does not have a contractual relationship with that school. I have the contractual relationship with that school. I'm the one who's engaging. If I send my child to a daycare, I'm the one who's making the decision to send my child to the daycare. I'm the one who's engaging the daycare.
You're missing the point of my question, which is, under your interpretation, the legislature has expanded any given employer's liability to encompass this private cause of action whenever a child might be implicated in the underlying report, regardless of the nature of the business that is dealing with the employee that made the report.
Well, here again, we have an issue where she is on the job, doing an inspection of the apartment,
or an eviction because the mom didn't pay the rent, right?
I don't recall the exact circumstance under why she was in the unit, but
I think that she said, I think those were her words, that they were doing an inspection attendant to an eviction.
But again, the issue is that they are. I think that the legislature intends to provide protection for employees who report abuse of children broadly? I do. Do we have to reach that in this case? We don't. Because in this case, we have an entity that almost 50% of the residents of it are children. The children can't enter into contracts with the housing authority, but they are certainly the beneficiaries of the services. They get the housing. I mean, that is among the most basic, literally, I would argue, food, housing, clothing are among the most basic.
But you also agree that having a child is not a condition to being able to receive the housing benefit from the housing authority.
Some of the programs require that you be a family. But
is there any evidence in this record that the St. Pete Housing Authority limited the provision of the services, i.e. the housing, to people that had children? And I'm asking you this because if we're going to write, say, an opinion reversing, we have to confront that. And the way I'm struggling with, how do we confine or define what is facility serving children in a way that makes sense relative to the context of this provision and the words that are used in it.
Well, to address that problem, I think, again, my primarily, I would say A and B are different. And the legislature has instructed us that A and B are different. But if we put that aside, which again, I don't think we need to.
Mr. Barak, I don't want to interrupt you, but you're at your 5 minutes, so you can keep going, but 5 minutes is what you have left.
I appreciate that. I do want to also say that I think that first, I think again we can break these out, and we should break them out. But even if we don't, and you bundle them together, again, we've been instructed to say that there is no basis to say that they are not a facility serving children. I think it's important to mention during my time that in this case, the summary judgment rules were not followed. There's no basis to find that the summary judgment rules were followed. They filed material supporting their summary judgment, which the court relied upon 7 days before the hearing. That is improper. This is not a tipsy coachman right for the wrong reason case. They just didn't follow the rules, and that is improper. And the opinion cannot stand on that basis as well. And I'm going to reserve, I think I have 4 minutes left, Judge.
Exactly right. 4 minutes and 1 second.
Had a timer.
4 minutes, you got it. All right, we're moving on to Mr. Thompson.
May it please the court, Eric Thompson for the appellee, St. Petersburg Housing Authority. To reverse the trial court, the appellant asks this court to do two things: to violate numerous canons of statutory interpretation and to violate a basic tenet of law, that one who does not have a right cannot file a cause of action to enforce that right.
I don't want to interrupt you, but could you deal with his last point first? Because
Sure.
if the rules of summary judgment weren't followed, then who cares about the rest of it?
I will deal with that, Your Honor.
All right.
The evidence in the record, based on the evidence in the record as submitted by the appellant, establishes there is no dispute, and the appellant didn't dispute below and doesn't dispute here, that the housing authority is not an entity designed to primarily serve children, which is the legal stand or the interpretation that the trial court determined. That's not the dispute. The dispute here is whether the trial court correctly determined that the housing authority has to primarily serve children, or as the appellant contends, it just also serves children, or one of the other tests lobbied in the briefing, it regularly comes into contact with children. There was no dispute below as to that fact. And under 1.510E3, if a party fails to properly support an assertion of fact or fails to properly address another party's assertion of fact, as required by Rule 1.510C, the court may, subparagraph 3, grant summary judgment if the motion and supporting materials, including the facts considered undisputed, show that the movement is entitled to it, end quote. And in the record, on page 286 of the record, which is page 8 of the motion for summary judgment, in addition to the lack of any evidence that the housing authority primarily serves children, there was the HUD website, which was cited, which is the purpose of the housing authority, which is to provide housing for low-income families, the elderly, and persons with disabilities. So everybody, not designed primarily to serve children. So this is a classic application of the Tipsy-Coachman doctrine. The trial court reached the correct result. So that's the issue with the evidence on the record. Now, looking at the statute 90.203, it's divided into two subsections. We have subsection 1, which is what I refer to as the shield for all. In that subsection, the legislature specifically provided that, quote, any person, end quote, is protected from civil and criminal liability for reporting child abuse or suspected child abuse. So in that subsection, the legislature specifically applied it to, quote, any person, end quote. And that's a defensive right. So because that's a defensive right, the legislature didn't need to provide for a cause of action in that subsection. Now, subsection 2, the subsection we're here about today, applies to, quote, resident or employee of a facility serving children, end quote. That's who the anti-retaliation provision applies to. That's paragraph A of subsection 2. Paragraph B of subsection 2 creates the cause of action to enforce that right. So we have subsection 1, which applies to a certain class of persons, which is any person who reports child abuse. they are granted civil and criminal immunity or immunity rather from civil and criminal liability. And then we have subsection 2, which is the anti-retaliation right, which applies only to residents specifically, only to residents and employees of a facility serving children. Now, if the legislature in subsection 2 wanted to open that up to any person, as they did in subsection 1, they certainly could have done that. If they wanted to open it up to any resident or employee of any facility without any qualifiers, they could have done that. They knew how to do that in subsection 1, but they explicitly didn't do that. Now, unfortunately, again, that term, facility serving children, wasn't defined. So, canon of statutory interpretation, we usually give words the ordinary and plain meaning that's generally attributed to them. Here, we're not dealing with a single word that we could simply look up in the dictionary. We're dealing with a specifically created legislative phrase. So another canon of statutory interpretation, quote, to ascertain the meaning of a specific statutory section, the section should be read in the context of the surrounding sections, end quote. And that's the Meeks case cited in our briefing.
I would like to shift your focus for just a minute to Judge Valenti asked you a question about, or asked your opponent a question about there was dialogue about the summary judgment evidence.
Right.
If we view the initial question as the legal one concerning the application of the statute, does Blanchard's affidavit, I think that was her last name, right?
Mm-hmm.
Tanya Blanchard. That's the late filed affidavit. Does that come into play if we say, this only applies to facilities serving children, and 2B doesn't afford an independent cause of action unless you meet the criteria of 2A, then does it matter about Blanchard's affidavit?
No, because the evidence that was submitted, there's no dispute that appellant's evidence in which it attached to its response was timely submitted. There's no dispute as to that. And the argument there was the housing authority is a facility serving children because it serves children in addition to adults. Here's the evidence of that. And counsel recited that earlier, which was that of the approximate 3,300 families, I think it's 1,600, so a little less than half, have children. And then there was some Facebook posts, which were, I guess, originated from third parties that the housing authority shared. That was the evidence to say, trial court, the housing authority is a facility serving children, not primarily, but they also serve children. That was the evidence. That was all the evidence that the trial court needed to submit or to rather consider based upon its test of.
So in cutting to the chase, right? Sure. The only way that the material from the Blanchard affidavit becomes relevant is if you clear the legal hurdle of, does this particular plaintiff enjoy the private cause of, as a matter of law, enjoy the private cause of action afforded by 2B? And if she does, the material in the Blanchard affidavit creates an issue of fact that would have to be addressed on remand. Do you agree with that?
I agree with that, Your Honor, yes. Okay. So without a definition to look to, the trial court consulted the surrounding sections, and they looked at 39.01, which has two pertinent definitions, subsections 34, which now is actually subsection 39, subsection 54 at the time, which is now 57, in which it was the two definitions, institutional child abuse or neglect, and then other person responsible for a child's welfare. And in both of those definitions, why are those important? Because those are two other subsections where the legislature in Chapter 39 used the word child and facility together. And how did they do that? And actually employees. In defining certain classes of people who are accused of committing child abuse, it referred to employees of schools, daycare centers, residential homes. Then it used the phrase, quote, institution, facility, or agency, end quote. And actually in subsection 36 qualified that with responsible for the child's welfare. Did the same thing in section 54. And actually in subsection 54 also referred to law enforcement officers, but not any law enforcement officer, only law enforcement officers that are employed by a, quote, facility, service, or program for children, end quote. So the trial court sees those two definitions. And in the context, they're saying child and facility are used in with regards to facilities or entities that are primarily designed to serve children. Schools, daycare centers, residential homes, and in the case of law enforcement officers, only law enforcement officers that are employed by a, quote, facility, service, or program for children, end quote. So the trial court sees those two definitions. And in the context, they're saying child and facility are used in with regards to facilities or entities that are primarily designed to serve children. Schools, daycare centers, residential homes, and in the case of law enforcement officers, law enforcement officer or employed in a facility, quote, for children, end quote. And two other canons of statutory interpretation, which I know your honors are all familiar with. The associated words canon, words associated or grouped in a list should be given their relative meanings. And the adjustum generis canon, that where general words follow an enumeration of two or more things, the general words apply only to persons or things of the same kind or class specifically mentioned. So here we have the general words, institution, facility, and agency following schools, daycare centers, and residential homes. So a facility under Chapter 39 is of the same kind or class as a school, daycare center, and residential home. So seeing that, the trial court correctly determined that a facility serving children is, quote, it was an entity to, quote, designed to promote child welfare as its primary purpose, such as an educational facility, a daycare facility, etc., end quote. It did not, as the appellant claims, insert its own language. It had an undefined legislative term. It did what it was supposed to do. It had to interpret that legislative term, and it looked to Chapter 39 to do so. And it did not stop at Chapter 39. It also looked at the sparse case law, even referencing the phrase facility serving children. That was the Norman case, the Williams case, and the Iorio case that's cited in our briefing, Your Honors. And I just want to highlight the Iorio case because I think it's the most instructive. In that case, there was a claim under 39.203 filed by an employee of a law enforcement agency. He was actually a deputy sheriff. And the court in that case said, you plaintiff, do not qualify as an employee of a facility serving children. Obviously, law enforcement agencies, like housing authorities, serve both adults and children, and also regularly come into contact with children. Yet the Iorio court said you are not an employee of a facility serving children.
Before you run out of time,
Sure.
Can you address the hypothetical that I put to your opponent with respect to Chuck E. Cheese, and then we kind of came up with this, the employee assaulting?
Yeah,
Because if you read the language of B, any person making a report under this section has a civil, it's basically a whistleblower. And why does that? And I hear what you're saying with all the principles of interpretation, although the legislature certainly could have used a parallel provision in B, and they didn't. So against that backdrop, why should we not agree with your opponent on his broader interpretation of 2B?
Because as Your Honor astutely pointed out, the list there is virtually endless. We're talking about restaurants, clothing stores, grocery stores, pharmacies. In fact, in thinking about this myself, what entities wouldn't be included? Would not under an entity that serves adult and children?
And how do we know that the legislature didn't intend to set that up?
Well, they didn't intend to set that up is because that would, one, there's no predictability. We all know what entities are designed to primarily serve children. We all know that. We can all predict that, including the employees of those entities, so that they know they're protected and that they can be encouraged to report the abuse. But also, we know that from sub A. Sub A is specifically limited, or paragraph A rather, is specifically limited. They specifically use that limiting phrase. And now paragraph B, the appellant is arguing, well, it says, quote, any person making a report under this section, end quote. So they're saying because this section, it references this section, that's a broad term. And I think Judge Black's opinion in the Alvarez-Soles case, which is 386 Southern 3rd 224, which is cited on page 26 of the initial brief, is very instructive on this. That case, we had Pasco County, it was the obligation of the county to fund a criminal justice information system. And that obligation came from an amendment to the Florida Constitution that said the county has an obligation to fund the, quote, existing, end quote, criminal justice information system. Then there was an implementing statute that was enacted when that constitutional amendment passed that also referred to the existing system, but that statute also referred to updates. So once the lawsuit got around, the system that was in place at that time it had been updated. So the county was saying, hey, look, we don't have an obligation to fund this because this is not the system that was existing at the time. And as Judge Black pointed out in that opinion, to read existing so narrowly, like reading section so narrowly in this case, would require the court to completely ignore the reference to updates in the implementing statute. In doing so would violate numerous canons of statutory interpretation, including giving that the meaning and effect, significance and effect, is to be given to every word and phrase in the statute, and that the sections of a statute are to be read in accord with each other to give meaning and harmony to the entire statute. And so exactly what Pasco County was asking this court to do in Alvarez-Soles, read existing extremely narrowly, so you're going to read out other legislative language, is exactly what the appellant is asking the court do in this case, and exactly what the court should refuse to do in this case. Now, getting to there's two standards in the briefing that appellant asserts. That first, in the initial brief, it was, well, this is any entity that serves adults and children. Then in the reply brief, it became, well, it's any entity that regularly comes into contact with children. Now, under either scenario, there's no authority, statutory, case law, or otherwise, for either standard. And as I was indicating earlier, either standard produces an endless list of entities that may or may not be considered a facility serving children. And in fact, the only ones that wouldn't be would be places where children aren't allowed. Places that wouldn't regularly come into contact with children are basically places children aren't allowed. Bars and clubs and places like that, which if that was the legislature's intent to only exclude those entities, why only exclude those entities? Why not just include anybody at that point? And I'd argue even bringing a child into any of those sorts of environments would in and of itself be child abuse. And why would we even want to exclude those sorts of entities? But beyond that, the regularly comes into contact with children test, there's gradations and case-by-case analysis that completely destroy any predictability for the statute. Now, in their briefing, appellants argue with regards to doctors. Okay, not all doctors are facilities serving children. Pediatricians are, family doctors are, but geriatric physicians are not. Taking the example of family doctors. Okay, well, even though all family doctors can treat patients of any age, including children, depending on where they are, if they're in a small town somewhere with no or little children, or not many children, they may never, if ever, treat a child. So then you have to look at each family doctor and determine, okay, does this family doctor constitute a facility serving children? Does this one not? Same could be applied to barbers, to housing authorities, like we're talking about in this case, to homeowners associations and condo associations, which is what appellant's rationale extends to. Then there's absolutely no predictability to that, which is why the trial court's interpretation makes sense. It's predictable. I'm
going to ask your opponent this since you brought it up, but the next hypothetical, of course, is somebody brings a child into an adult nightclub, and a worker of the nightclub reports and gets fired because of having made the report. There's some appeal to that in the purpose of this statute.
Yeah, well, we would want to, I agree with your honor. We should encourage the reporting by any employee of child abuse. But the legislature specifically chose, for whatever reason, chose not to do that. It certainly, a nightclub cannot be considered a facility serving children. It certainly can't be. So the
be a facility supporting the trafficking of children, but not a facility supporting children.
Exactly. So the legislature decided to draw a line somewhere, and it was at facility serving children. Now, why it did,
under your construct, then there's a common sense component to this. You're saying predictability, but if the legislature had intended this to be so expansive, under your theory, they would have been clearer. And is that right?
Correct. And here's the issue with paragraph B of subsection 2 is, but the legislature, I'll agree, was imprecise when it used the word section. But hearkening back to the Alvarez-Soles case again, to read that term section so narrowly, to read out of paragraph A, facility serving children, violates numerous canons of statutory interpretation. But that wasn't the only instance in paragraph B where the legislature was unfortunately imprecise. One of the arguments made in the initial brief was paragraph B doesn't gel I'll say with paragraph A, because paragraph B only applies to employees. That's not true. Paragraph B is comprised of two sentences rather. The second sentence refers to both residents and employees. The first sentence, however, only refers to employees. So unfortunately, again, another instance of within paragraph B, the legislature was imprecise. I'll concede that. But that doesn't mean this court should then read out of the statute a limiting phrase that the legislature specifically decided to use because, again, that completely violates the tenets set forth in our.
Mr. Thompson, I don't want to interrupt you, but you have 1 minute to go.
Thank you, Your Honor. And I'll just wrap up finally with one point. The appellant claims that the trial court's interpretation would not protect certain mandatory reporters, as the appellant terms it. First of all, under 39.201, we're all mandatory reporters. If we see child abuse or have reasonable cause to suspect it's occurred, we have to report it. What appellant is referring to as mandatory reporters is certain individuals who can't report anonymously, which includes any and all physicians. But ironically, appellant's argument also excludes those quote unquote mandatory reporters because they argue in the briefing, geriatric physicians aren't facility serving children. Yet they're quote unquote mandatory reporters under 39.201. So even appellant's argument excludes them from protection. Again, the legislature chose to draw a line at a certain place. Whether they need to redraw that, that's the legislature's purview. So with that, Your Honors, I would request that the trial court's order be affirmed. Thank you.
Thank you, sir. Mr. Barak, I said you had 4 minutes left, right? So your time. I think your mic is on mute.
I apologize. So a couple of points. One, I think the legislature said this section. We have a rule of construction that says a section is the entirety of the section. And so the legislature said this section. We can't ignore that word choice. That is the legislature's word choice. We have to give meaning to that word choice. Also, with respect to the legislature's word choice, facilities serving children.
Before we get there, you would agree that this section is in its entirety 39.203 and all of its subparts.
So, yes, the chapter is 39, the section is 203, the subsection
subsections
is
are
2, and then paragraphs are under that. So if they had said under this subsection, then they've got a much stronger argument. But they didn't say subsection. They said section. And we have to give meaning to their word choice because section means something in the context of the Florida statutes. It means something. It doesn't say subsection. Subsection is 2A and B. Section is the entirety of the section.
Even under that read, you're still stuck with the entirety of the language in A, which talks about facilities serving children. So help me out with that.
I'm sorry, you're talking about in A1? A1 doesn't say anything at all about.
Under 2A. We have to read the whole section.
Right.
In its entirety.
Yes.
You're saying that the legislature, if they wanted to do what your opponent thinks should be the outcome here, they should have said a report under this subsection.
Right.
In order to have it be limited. But that does then somewhat constrain our ability to read the whole thing together and try to arrive at a reasonable meaning for all the words as they're used in this context.
I don't think any person it says any person. So that means any person.
And under this section, which includes 1A and 2A, as well as 2B, right?
Right. So that's so yes. So I think that any person under this section, which would include 1A, so any person is any person making a report, which is the 1A portion of it. That's what they're talking about. They're talking about the person who makes the report under 1A. Right? That's the reporting section is the 1A and says you have immunity if you make that report and then they fire you, well, you can sue them. And that's what we want as a society. Let's be clear, as a society, we don't like child abusers. And we think child abuse is bad. And we think people shouldn't be fired if they report child abuse. That's a child. I mean, I don't want to belabor the point, but I don't think child abuse is a good thing. And I think we want to protect people who are reporting child abuse. I want to make a point about the facility serving children language, which I think is important. The legislature when the legislature uses different words, they intend different things. And they used different words there than they did elsewhere. Elsewhere, they talked about schools. Elsewhere, they talked about daycare centers. Here, they just said facilities serving children. We have to assume under the rules of statutory construction that they intended something different when they said something different. And they did.
Mr.
Yes.
Baraka, again, I don't want to interrupt you. You got about a half a minute left to wrap up.
I appreciate the court's time. This is a case where the trial court made an error. It needs to be reversed, and the case needs to be remanded so that we can proceed to trial. Thank you.
All right, well done, gentlemen. We're going to move on to the next case. The last case of the day, or the morning session, is Crete Carrier Corporation versus Marlon Moore et al. There we go. Okay. Mr. Butler, you're the appellant.
Yes, Your Honor.
Are you ready? Both sides ready? Let's go.
Yes,
20
Your
minutes.
Honor. Good afternoon. My name is Jesse Butler. I'm here on behalf of the appellant. I'd like to reserve 3 minutes for rebuttal, if I may.
Yes.
Thank you. We've got two issues that we have appealed, primarily with regard to the court's abuse of discretion following a jury trial. I'd like to start with the second argument in our brief that had to do with the improper closing presented by plaintiff's counsel. Florida law is very clear that what plaintiff's counsel did in this case is improper. Plaintiff's counsel, having moved in limine to exclude evidence and arguing that evidence, the date that he was involved in this case, and specifically that the doctors who were treating under a letter of protection knew that the plaintiff was represented the entire time of their treatment. Plaintiff's counsel argued before trial that the jury shouldn't hear that it was irrelevant, that the fact that there was an LOP, well, first they argued that shouldn't be in, but they argued that any reference to the plaintiff's firm, any reference to dates should be excluded. Having won that argument, counsel then, during rebuttal, when there was no possible time for defense counsel to respond, took advantage of that ruling and actually misrepresented the facts to the jury. Counsel stood in front of the jury and said, our office wasn't even involved in this case until January 2018. That was false. It was a blatant misrepresentation. Counsel knew he had just excluded all the evidence that
Your opponent has a slightly different take on how you got to where you were in closing argument. If I understood the briefing correctly, their view of it was that your trial counsel managed to get some of that information in and that they rebutted it. Help me, if I'm wrong about that, you'll educate me.
Yes, Your Honor. Plaintiff's counsel is incorrect on how this came in front of the jury. So there's two issues that they primarily argue. And their brief, they don't really even argue that what plaintiff said was proper. What they say is, well, there was a hearing and the court didn't explicitly prohibit this document, this authorization from going to the jury, and didn't expressly prohibit some testimony from Dr. Brotherton. But that's not really what the court did. There was a hearing on the objections to both Dr. Mazur and Dr. Brotherton, who are in the same practice. It was a hearing on the deposition objections. The supplemental record highlights what those objections are. The plaintiff's trial counsel argued, and it's at page 1341 of the record, when they started this argument over the objections, he says, we're talking about Dr. Brotherton and Dr. Mazur's deposition. As an example, he says, let's look at this section of Dr. Mazur. And then there's prolonged argument, and the court says, okay, I'm going to order the parties take out references to the plaintiff's counsel and to the date and to the fact that the doctors knew from the start of their treatment of this individual, Mr. Moore, that he was represented by counsel. Ordered that. Now, the court then goes on to another issue. What's notable is the answer brief on the one hand says, well, the judge didn't expressly exclude this. But then going on later in the answer brief, the counsel says, counsel certainly violated the spirit of the ruling, saying that the defendant, by introducing the LOP, violated the spirit of the ruling. Clearly, both sides understood that the judge's ruling was you have to take out any reference. Even though he expressly was dealing with one section, that was an example. And attached to the motion for rehearing that the defendant filed were the emails, which are at page 1391. Following this email, plaintiff's counsel is saying, here are the sections that need to be redacted based on the judge's ruling. So plaintiff's counsel is taking the position that all of this needs to come out. What they are arguing is, well, the defendant got the LOP in, which first of all, the judge never said had to come out. That went in. The LOP, which is at page 817 of the record, which is called an authorization and promise of payment. Plaintiff's counsel below tried arguing it wasn't an LOP. The trial court said, I don't care what you call it, it's an LOP. That document is notable, it's different than what defense tried to get in, because although it's dated 11/21/17, it doesn't specifically list the plaintiff's law firm on that document. This is a document that the doctor's office generates. That is different than the authorization for medical records, which was at page 1359 of the record, which was a document generated by the law firm. And it specifically says that Marlon Moore authorizes the medical office to provide to the law firm of Tandy Griffith and Bresler, PA, the following records. The law firm is mentioned 3 times. It talks about this is for a personal injury claim, and it's dated 11/2017. And there's a fax receipt showing it went out in December of 2017. So that is very different than just the blank LOP that just says I'm going to be treating, and if there's a claim, it shows definitively that there was a claim, that plaintiff was represented. And more than that, what plaintiff told the jury was false. I mean, it was just blatantly untrue. When he told the jury in closing, our firm wasn't involved, he said, November 21st, we became involved with this January 3rd of 2018. He's trying to downplay the significance of the letter of protection. He's saying, look, I know they showed you a letter of protection from November, but we were not, he says, we were not involved until January 2018. That is false. And he's trying to downplay the potential bias of these the doctors by misrepresenting facts that he knows is untrue based on taking advantage of a motion that he won. So I don't see, this argument that, well, this really doesn't matter. There's no prejudice because they got the LOP in. As I said, the LOP doesn't have the same information. It doesn't adequately respond to, even if it did, I mean, defense counsel can't do anything at that point on rebuttal, can't get back up and say, well, let's take a closer look at that. That evidence was supposed to be excluded. Plaintiff's counsel said the jury shouldn't hear the date we were involved, and then gets up and says, hey, we weren't actually involved until 2 months later. So, and that's, to me, a blatant example of the type of closing argument that this court and other courts have found is an abuse of discretion for the trial court not to declare a mistrial. I mean, in State Farm versus Thorne, this court about a decade ago said, it's improper. The law on this point is clear. Case law indicates it's improper for a lawyer who has successfully excluded evidence to seek an advantage before the jury because the evidence was not presented. That's exactly what happened here. And we cite a number of cases in our brief. I mean, there's no way around it. They argued this should come out. They got their way. Everyone acted as though they got their way. And I wanted to point out in the Allstate versus Lewis case, which we cite, 2009 from the first DCA, that had to do with a motion in limine, and the court said, Although the trial court did not explicitly rule on the motion, it's apparent from the discussion before and during trial that the trial court and the parties understood the motion had been granted. That's very similar to what happened here. Plaintiff's counsel moved to exclude all this. The judge said, yeah, you've got to take it out. And though the trial judge didn't go line by line through every deposition, plaintiff's counsel following the hearing says, hey, we won that issue, all this has to come out. And everyone acted as though that's what happened. And then they took advantage of that. So, I mean, on that issue alone, I don't think that that kind of conduct can be condoned. And we know it was important to the jury because during their deliberations, they sent out a juror question asking for more information about this authorization and promise of payment. This was on the jury's mind during their deliberations. And what they were left with, the last thing they were left with was false information that plaintiff's counsel wasn't even involved during the first couple months of Mr. Moore's treatment with these doctors. That was what they wanted to leave the jury with. And that was blatantly improper. The second issue that we've raised in our brief is the trial court's failure to strike the plaintiff's expert, Dr. Kowalski. And the issue essentially, I think, comes down to two primary issues. First off, the court failed to conduct any kind of Binger analysis as to whether the untimely disclosure of Dr. Kowalski's opinions should have been excluded under Binger. And I would point out in Montero, the third district said it's incumbent upon the trial court to analyze these Binger factors.
But before you get too far into that argument, why was Kowalski called late? Can you explain to me what happened?
Yes, Your Honor. I acknowledge, I mean, I was not trial counsel, but reviewing the record, there were issues with both sides trying to get discovery from the other side.
Was he called in rebuttal?
He was listed as a rebuttal expert. And part of the problem here—
And was he called in rebuttal?
Yes, Your Honor.
So you acknowledge some fault was on trial counsel?
No, Your Honor. What I want to point out is that Dr. Kowalski was listed as a rebuttal expert. Weeks, if not months, before trial, defense counsel moved to strike Dr. Kowalski as an expert because they had been trying to get his opinions through discovery. Plaintiff's counsel never gave those opinions. There was a hearing about 2 weeks before trial where a motion to strike Dr. Kowalski was heard based on defense counsel arguing, Judge, I don't have this guy's opinions. They won't give me a deposition. I don't know what he's going to say. The trial judge ordered that his deposition take place about 2 weeks before trial and ordered the plaintiff to provide Dr. Kowalski's opinions to defense counsel ahead of that deposition. Neither of those things happened.
You took the counsel took the deposition of Kowalski, correct?
Eventually. But Dr. Kowalski failed to appear at his first deposition 2 weeks before trial. And plaintiff's counsel didn't provide the opinions that the court said you need to provide. Defense then files an emergency motion, renewing its prior motion, saying, hey, we still don't have this guy's opinions a week before trial. And the judge orders that the Friday afternoon before Monday trial, defendant will take Dr. Kowalski's opinions and that the opinions should be a report or something should be disclosed before that. Defense counsel doesn't get those opinions. So Friday afternoon before trial walks in blindly to find out for the first time what Dr. Kowalski's opinions are. Then during the trial, obviously at that point, having only taken the deposition the Friday before trial, there's no earlier time to file a Daubert motion than during trial. And plaintiffs or appellee's counsel, mentions in the brief, well, it wasn't until the fourth day of trial that we brought up the Daubert motion. But how is defendant supposed to bring up the Daubert motion any sooner when the deposition revealing the lack of the basis, a scientific basis for these opinions?
Well, I have a question. The argument was that Kowalski wasn't qualified. Is that the sole argument for the Daubert hearing? He wasn't qualified, but everyone seems to agree he was highly qualified as an expert witness.
I think the issue, Your Honor, is he is highly qualified as a medical doctor. He does have a background in engineering, but the trial court, the issue is the trial court never did an analysis of whether Dr. Kowalski was qualified to give biomechanical engineering opinions.
Okay, was that specific argument made in trial?
Yes, and again, what happened was defense filed a written motion. Defense was then forced into arguing a very abbreviated hearing right before Dr. Kowalski was called to the stand, because again, the deposition wasn't taken until Friday afternoon before the start of Monday trial. And that's part of the Binger analysis that didn't take place. Was this going to disrupt the trial? Because defense is saying, this guy, we don't have his opinions. They shouldn't be allowed to call him.
Well, there was no motion to continue, was there?
I don't believe there was, Your Honor. And the case law says at that point, defense shouldn't be forced to ask for a continuance was there a showing of prejudice? Well, that's the thing, Your Honor. Once the argument was raised that this was an untimely disclosure, their position was, well, we disclosed him on a witness list, but they never disclosed his opinions. There was an obligation to actually do that analysis. As the court in Montero, in 2021, third district case said, it's incumbent upon the trial court to analyze the Binger factors before exercising its discretion to admit or exclude late disclosed exhibits.
Mr. Butler, did you want 5 minutes for rebuttal?
3 minutes, Your Honor.
All right, keep going. You're only at 5.5.
All right, thank you, Your Honor. So the court the court said the trial court's failure to do so will result in reversal. Here, the court never analyzed, never made findings, never even analyzed prejudice, never analyzed whether this was going to disrupt the trial. And what we see is it did, because by being forced into taking an 11th hour deposition, the Daubert challenge couldn't be brought until mid-trial. And at that point, we have another issue where the trial court fails to conduct a Daubert inquiry, and it fails to do any kind of Daubert analysis, even though the written motion is a Daubert motion challenging not just his credentials, but his methodology. And it's very abbreviated. Appellee's counsel here says, well, it was only 6 lines or something of the record. But how much longer can it be when you're literally having this argument before the witness is called to the witness stand? Defense counsel says we filed a motion, challenges him under Daubert, and the court, under Ban, which is a first district case, 2015, the proponent of expert testimony must, when properly challenged, establish the basis for its admissibility by a preponderance of evidence. That didn't happen. The plaintiff never tried to establish why his testimony met the Daubert standards. In Kristen, first district case from 2021.
You're at your 4-minute mark. You can keep going if you want to.
Thank you, Your Honor. But in that case, in Kristen, the court said, this does not mean the trial court, even during a bench trial, has the discretion to decide not to perform the gatekeeper function at all. And it's an abuse of discretion for the court to abdicate its gatekeeping function under Daubert. That's what happened. I in some ways have sympathy because we're in the middle of trial, right before the witness is coming up. I don't, in some ways, fault a trial judge for being hesitant to having to do a Daubert inquiry, but that's what was required. The issue was raised that this expert, who I should add, he says during his deposition, big red flag, I'm different than other biomechanical engineers. He says he starts with a medical diagnosis. He starts with a differential diagnosis, which by that point the court had struck. And if you read his trial testimony, there is his testimony boiled down to if the vehicle Mr. Moore was in was damaged, then I've read studies that show that the amount of force necessary to cause crush damage, even in a low speed impact, is sufficient to cause some injuries to somebody. And I've read that somewhere. Just saying you're in an accident and you can see damage, because all he did was look at photos, didn't do a single test, didn't do a study, didn't do any measurements. He testified at one point, well, the truck was 50,000 pounds. Turns out during cross-examination, he goes, well, it may have been 10,000 pounds. I don't know if that, he wasn't sure of the weight of the vehicles. He said during his testimony, you can't calculate things in a low-speed accident, when that's exactly what our expert did. He essentially says, in a low-speed accident, I get to go up and say, I see damage to a vehicle. I've read studies that say, as long as the vehicle's damaged, a person can be harmed. That didn't qualify.
You're at 2 minutes. Did you want to save that for rebuttal or you want to keep?
I will, Your Honor. Thank you, Your Honor.
All right. I'll save you 2 minutes. Ms. Peak Luca?
May it please the court, Megan Peak Luca for the appellee. Is there a place where you would like for me to start?
A place? Right where you sing is fine.
Is there an argument with which you would like for me to start?
I would think you probably want to rebut his argument. He took his arguments in reverse order. You can take them in any order you want.
All right, I'll start by fact checking what he told you about the closing argument. I would point you to R 1339, page 10 at line 13. What counsel represented about what the plaintiff's counsel moved to exclude was not accurate. Plaintiff's counsel told the court that specifically, the court said it was not appropriate to be talking about whether or not a doctor knew that an attorney was already hired when the plaintiff goes to see the doctor. Certainly, to the extent Mr. Darberly, defense counsel, wants to bring up bias, I don't have a problem with the fact that they knew he was in a car accident. I don't have a problem with the fact that there's a problem to pay the outstanding medical bills from any proceeds of the case. That's fair game. But questions regarding whether Mr. Moore knew he was represented, or whether Dr. Mazur knew Mr. Moore was represented or not, I think based off the case law is absolutely inadmissible.
Well,
And
I
the
think his
reason
argument is, I think his argument was they took advantage of that ruling to misrepresent the timing of the representation. Is that true or false?
That is absolutely false, Your Honor.
Keep going.
Mr. Moore's counsel explained during this hearing, look, my problem with that line of questioning is because it suggests that we, as Mr. Moore's lawyers, sent him to go see Dr. Mazur. We did not do that. Therefore, we don't want this question to be asked. And the judge said, I agree with you. The case law supports you. You got to redact that portion of the question. So we get to closing argument, and defense counsel, in a very smooth way, suggests to the jury, because they had agreed that they were going to redact dates, somehow this date on the LOP, and I encourage you to go take a look at the LOP. It is at R817. The date slips through. Defense counsel puts it on the overhead, and he says, hey, jury, go take a look at this. It's dated 11/21/17. That's 11 days, 12 days after the accident. And here it says, I authorize and direct my attorney to make payment. And he's making the suggestion of exactly what we tried to exclude, which is that Mr. Moore's lawyers sent him to go see this doctor, so the jury shouldn't trust what the doctor has to say. So Mr. Moore's counsel got up on rebuttal, and what he said was, we became involved in this, and he's pointing to the LOP, January 3rd of 2018. And he says the purpose of this letter to Mr. Griffith, and what he's referring to, is R818, which is a fax from orthopedic specialists to Mr. Moore's lawyers saying the purpose of this letter is to advise you that we have a signed promise to pay on file in our office, which we are forwarding to you with this letter. So Mr. Moore's lawyers are saying, look, we didn't become aware that there was an LOP until January 3rd. All he's doing is saying, to the extent that the defense is suggesting that we sent him to the doctor, we didn't do that. Defense counsel understood that that is what happened, because when defense counsel moved for his mistrial, he said, for the record purposes, for the statements that were made in rebuttal closing regarding the timing in which the plaintiff's firm became aware of the letter of protection or promise to pay, and that's at transcript 928, lines 20 through 25. And the trial judge, who was sitting there and watched what happened, watched what was pointed to, said, I find that absolutely nothing occurred in the presence of the jury that would reach the level of diminishing the fairness of these proceedings. That's at transcript 919, lines 21 to 24. You all don't disturb decisions like that lightly, because you have said that the trial judge has a superior vantage point that we don't get from a cold reading. The trial judge saw it, even defense counsel saw it. The way that it is being characterized in the briefs and at oral argument is contrary to the record. And there is no, I think counsel, the other point that I wanted to make was that The defendant has never articulated any kind of prejudice that resulted from this. It is a tangential argument about the credibility of a doctor's testimony. There was plenty of other testimony in this case that supported the only issues, which were causation and damages. The error is harmless. Defendant has never tried to articulate to you how the prejudice could occur. And the only thing that defendant can rely upon is this line of cases that says that it's error to allow a party to exclude evidence and then to point to the absence of the evidence. That is not what happened here. As to the Daubert motion and the striking, I spent a lot of time in the brief laying out the procedural history. The defendant never complied with the pretrial order. The plaintiff always complied with the pretrial order. Mr. Kowalski was disclosed timely as a rebuttal expert consistent with the pretrial order. The defense moved to strike him, and the court basically said, look, and I'm reading from the transcript, and this is in our appendix at page 50. What's good for the goose is good for the gander. You, defense, want me to strike the witness from potentially testifying in rebuttal because they didn't have enough to really prepare you for a causation expert who was disclosed as late as he was in the game. Essentially, hey, defense, listen, you all messed around and you disclosed Dr. Fijalkowski way late in the game. On March 29th, about 10 hours before Dr. Fijalkowski's deposition, the defense gave 756 new pages, 372 new images, and 108 new videos that were going to be relied on by Dr. Fijalkowski. The judge had previously said at the first motion to strike, I'm going to call him Dr. K because the skis get hard for me. So the judge said, look, plaintiff, give them Dr. K's opinions by tomorrow. All right. Well, during that hearing is when the defense document dumped all this information about Dr. Fijalkowski's opinion. And the plaintiff said, in response to the defense's renewed motion to strike, look, Dr. Kowalski is a rebuttal expert. We can't tell you what he's rebutting until we know what the information is, which is why we couldn't give you his opinions the very next day, because you waited until the absolute last second to dump all this stuff on us. And oh, by the way, the reason that Dr. K did not appear at his deposition is because of a death. The court goes off the record, but we do know that it involved the death of his ex-wife. It was personal, and the judge apparently had no problem saying, okay, that's a justifiable excuse. And that's all that's required, Your Honor, is that it be justified. And so at the end of the day, when the second motion came around, the judge said, look, my effort is to bring cases to trial and to have the jury decide the case based on all the relevant and admissible evidence and the law that applies to the case. He said, we're not striking witnesses unless they're total hacks. So is there a way this deposition can get taken? The plaintiff says yes. The defense takes the deposition 5 days before trial. The defense had a copy of Dr. K's deposition, which they gave to their expert. Their expert testified at trial. He had the opportunity to rebut anything he wanted to about Dr. K's deposition. The defense was able to vigorously cross-examine Dr. Kowalski. They were able to put on opposing evidence. The defense doesn't dispute any of those points. Moreover, let's say that the judge did abuse his discretion, which I really don't think that there's any way that you can say that two people could disagree about the outcome here. The judge clearly applied his discretion. It was a mess how late things were happening. And I don't think his decision was an abuse to just say, you two made your beds, go lie in it. You're both going to get late depositions. You're both going to get to trial. Make it happen. And they did. But even if that was an abuse of discretion, it still has to be harmful. And the law is that improper testimony may be considered harmless error where there is other sufficient evidence to justify the jury in reaching the conclusion supported by the opinion of the expert. And here, the only issues at trial were causation of the injuries and damages. And Mr. Moore testified that the crash caused his injury. The jury saw the pictures of the 18-wheeler and the car that was plowed into. Mr. Moore's doctors testified about how it was an acute injury, meaning it happened at the time that the films were taken, which was right after the crash. And Dr. Mahan, Mr. Moore's expert, testified that the findings from Mr. Moore's MRIs indicate that his L4-5 herniating disc was caused by this patient's motor vehicle collision of 11/8/2017. So basically, to prove causation, we didn't need Dr. Kowalski. He was a rebuttal expert. His only job was to say the defense expert's opinions are flawed, and here's why. And finally, on the Binger analysis, the word Binger appears nowhere in relationship to any of the defense's motions about Dr. Kowalski. And there is no case that says that when a motion to strike is denied, that you have to perform a Binger analysis. You have to perform Binger if you're going to strike. If you're going to deny it, even the case that the defense cites in their reply, Allstate versus Lewis, 14 Southern 3rd, 1230, a Florida First DCA case, says here a review of the record indicates the trial court did not consider the Binger factors, which it should have. Nevertheless, the record indicates that appellee was not prejudiced, Allstate did not comply with the trial order, and Dr. Von Thron's testimony did not disrupt or delay the proceedings. Here, Binger says prejudice is the #1 factor. There was no prejudice here. The defense got to take Kowalski's deposition. They got to vigorously cross-examine. I went through that. The objecting party's independent knowledge of the existence of the witness, that goes in our favor because we timely disclosed him. The calling party's potential intentional bad faith or non-compliance with the pretrial order. Again, we complied. And finally, the possible disruption of the orderly and efficient trial of the case. There was no disruption. Both experts testified. So finally, on the Daubert motion, the defense filed a total of 2 pages about Daubert. Their first argument was that Dr. Kowalski was unqualified. Their second argument, which is where the defense focuses, is that the Delta V opinion was not based on sufficient facts or data. They said nothing about that in the hearing. And I would direct you to transcript pages 569 to 573. That's where the defense presented their Daubert argument. No one cut him off. He was allowed to say whatever he wanted to say. I think you can surmise that he chose to abandon the issue because it was all based on the idea that Dr. Kowalski did not inspect the vehicle. Well, neither did Dr. Fijalkowski, the defense expert. So it was going to be tough to say Dr. Fijalkowski's methodology is accurate, even though he didn't inspect the vehicle, but Dr. Kowalski's is not sufficient because he didn't inspect the vehicle. Regardless of why they abandoned it.
That would have gone to weight, not admissibility, correct? Regardless. That would have gone to weight, not admissibility. Okay.
Absolutely, Judge Valenti. And regardless, the defendant never argued to the trial court that it needed to, defendant is arguing here that the trial court should be reversed because it didn't perform a Daubert analysis. To the contrary, the parties argued about qualifications. That decision is reviewed for an abuse of discretion. Dr. Kowalski was eminently qualified. He had a special grant given him to study precisely the issue that was in this case. And I didn't see anywhere in the briefing where the defense disputed his qualifications. So I think that's a gone issue. Again, I think the defense is hanging their hat on a technicality, and they're saying that it is automatic reversible error because the court didn't engage in a Daubert analysis on an argument that they didn't raise. They wrote it down and they chose to abandon it during the hearing. And the defense has it backwards. As Judge Panavato explained in one of his appellate decisions, it is the decision of the lower tribunal that was reviewed on appeal, not the issue. And that's from Hamilton v. R.L. Best Intern, which is at 996 Southern 2nd, 233 at page 235. Judge Padovano wrote, thus, the preservation of error requirement is not ordinarily completed until the aggrieved party has obtained a ruling on the motion or objection made in the lower tribunal. This court said in Newton versus South Florida Baptist Hospital at 614 Southern 2nd, 1195, pinpoint 1196, a party's failure to secure a ruling on an objection waives it. If they wanted to argue about the facts and data being insufficient to support Dr. Kowalski's opinion under Daubert, they had an obligation to say, wait, Your Honor, you only ruled on qualifications. You didn't rule on our insufficient facts and data. Let's talk about it. They did not do that. Therefore, you don't have a decision to review on appeal. And the qualifications, we listed them at page 26 to 27 of the answer brief. I don't think that I need to go through them. It sounds like you're fairly familiar with them. And finally, let's pretend that somehow it was improper not to do a Daubert analysis on an argument that was never raised. I think that's absurd, but I'm gonna go down my row of ducks. Even if it was improper, again, it's harmless because improper expert testimony may be considered harmless if there is other evidence that supports the jury's conclusion. And here, as I explained before, there is other evidence. Nothing Dr. Kowalski said was necessary to prove that the crash in this case caused Mr. Moore's injuries. And with that, I think I covered the watershed.
You have? All right, thank you. Mr. Butler, you had 2 minutes left.
Thank you, Your Honor. So first off, with regard to the improper closing argument, what I didn't hear is any justification for how plaintiff's counsel blatantly misrepresented the timing. There's no argument that that was wrong, because what we have is the doctors saying in November this law firm was involved. Plaintiff's counsel said they weren't involved until 2 months later. That was false. I think the authorization itself, the form, is somewhat of a red herring. It's one issue, but I find it interesting that they are arguing, well, the LOP, it was a mistake, the date wasn't taken off. That shows that everyone did understand that the judge's ruling was to take the dates off things, because there's also no express ruling to take the date off the LOP. Yet Appellee's counsel has said in their briefs and said today, well, that should have come out too. But they also want to say, but the court never actually excluded the authorization. Which is it? So clearly everyone understood that that's what the court did. But even if you take the authorization out of it, you have 2 doctors that the court expressly said, take the dates out, that testified that the plaintiff's law firm was involved in November, and plaintiff's counsel says the exact opposite during closing. We shouldn't condone that type of conduct. With regard to Dr. Kowalski, what I saw is that at page 1350 of the record, a hearing before his deposition, defense counsel is arguing this doctor has been struck based on Daubert before as a biomechanical expert. We're going to need a Daubert hearing. Then the very portion of the record that was cited, when they said there was a Daubert hearing, it's really just a few moments before he's brought up. The court says, and I tell you to look at the record at page 568 of the trial transcript, the court says you want him not to be able to testify at all due to some Daubert concern that his analysis wasn't based on sufficient data. And he goes on to say, is that a pretty fair summary of your motion? And defense counsel, Mr. Dubberly, says, yes, sir. Court says, all right, give me any additional argument.
Mr. Butler, before you continue, you are out of time. You want to wrap up in 1 sentence, 5 seconds?
Yes, Your Honor. The idea that the Daubert challenge was somehow abandoned when the trial court properly noted that the challenge was to the methodology. And if you examine the
Okay, I'll let you go over. You're well over the 5 seconds.
I would ask
Out of
that
time.
the court find the trial court abused its discretion on one or both issues raised on the appeal, and reverse the trial court's denial of the order denying motion for new trial. Thank you, Your Honor.
Well argued. Thank you both. I think that concludes the calendar. We'll be in
You guys are
recess.
finally done.
Have a nice day. We're finally done. You're right about that.
Thank you.
Bye-bye.
Bye.
Bye-bye, hon.